Even if you don't have a handbook, you should have a written policy that covers your obligations on sick leave, because there are aspects that need to be in writing. So address your accrual. If you're going to front load it, that makes things a lot easier administratively, most likely, but you then have a potential issue with the disparity between full and part-time workers, or full-time workers who, for whatever reason, aren't going to work enough to accrue the full 40 or 56 hours normally in a year. And, the issue of, would I be willing to err on the side of over providing a benefit up front? I should note that technically you don't have to use the calendar year for your sick leave year. You could run it some other consecutive 12-month period. It's a little hard to think that out because the law happens to take effect on January 1st, but you could somehow set up a different year if, for example, you wanted to front load, but you couldn't afford to have a bunch of people using the time in January. There might be a way to structure that meets your specific circumstances. The use issue is primarily one where you define whether there is any minimal increment. Again, you can't generally say people have to give you 5 days notice before using sick leave. You can say they have to let you know before they use it. And you might, if you have a pay time off policy, be able to carve out vacation time versus sick time as far as that goes. Annual limits, though, should be in writing somewhere, because again, the statute itself does not dictate the 40 or 56 as an absolute limit on how much someone can accrue or how much they can use in a given year. It just says you can put those limits in place. So I would, unless you intend to allow something different. As far as payout, again, address what you're going to do upon separation of employment. That's critical, especially if you don't want to pay it out. And then there is the concept in some existing policies of payout, for example, at the end of the year, or arguably even at any time that the employee asks for it. The law doesn't say anything about that or suggest that you have to do that. But again, it's something to consider whether for some reason you should. And then finally, I've kind of noted a couple of times there is an interaction with other leaves. That's something that if you are covered by the FMLA, for example, and most of you are covered by New York paid family leave, you should consider putting something in the policy to say, for example, if you want to use paid sick leave while receiving New York paid family leave benefits, then you can, or you can't, or whatever.